Thank you, Your Worship. State calls case number 20/06 of 2024. State versus Ntlantla Wise Boy Josie. Today, Your Worship, is the 29th day of January 2024. Court number 20. The appearances are as before. The presiding officer is Mr. Paper. For the state is Mr. Toti. Mr. Nompalweni, Your Worship, is our language practitioner for the day. And Ms. De Vries is appearing on behalf of the accused. This is a bail application matter, Your Worship, postponed for today for purposes of the defense to make their closing argument in support of their bail application, and also for the state to address the court on the reasons why it has been opposing the bail application by the applicant before this court. State is ready to proceed with the matter, as the court pleases.
May I please report, Your Worship? Your Worship, I do confirm that I'm still on record for the accused person. I'm ready to proceed with arguments as the court pleases, Your Worship.
Thank you. Thank you. May then proceed.
As the court pleases, Your Worship. Your Worship, I have provided drafted heads of argument. I believe a copy of my heads of argument has been provided to Your Worship as well as to my learned friends for the state, Your Worship.
Yes, I confirm that we've received a copy.
As the court pleases, Your Worship. For the benefit of the gallery and of my client, Your Worship, may I be allowed to read the contents into the record, Your Worship?
Yes, you may.
As the court pleases. The applicant, Mr. Ntlantla, Nice Boy Josie, applies to be released on bail in terms of Section 60, subsection 1A of the Criminal Procedure Act. The bail hearing commenced on 15 January 2024. The applicant herein stands accused on 3 charges, including kidnapping, murder, and extortion. The count of murder falls within the ambit of Schedule 6 of the Criminal Procedure Act.
Just before you proceed,
As
the
a
accused may be seated.
I thank the court, Your Worship.
Thank you. Proceed.
The count of murder falls within the ambit of Schedule 6 of the Criminal Procedure Act, the reason being that the state alleges that the murder had been premeditated. Due to the aforementioned Section 60, subsection 11 of the Criminal Procedure Act finds application, the onus rests on the applicant to prove, on a balance of probabilities, that exceptional circumstances exist which, in the interest of justice, permit the applicant's release on bail. Firstly, Your Worship, let me deal with the purpose of bail. The purpose of bail is to strike a balance between the interests of society and the liberty of the accused person. Pre-trial release of an accused person allows him to keep the fabric of his life intact. It enables the accused person to maintain employment and provide for his family. It also enables the accused person to take active part in the planning of his defense. In S versus Peterson and another full citation in my argument, heads, Your Worship, Cooper J. indicated that the purpose of bail is to minimize interference in the lawful activities of an accused person. It is important to note, Your Worship, that an accused person, such as in the applicant's case, has not stood trial yet, and as such is still presumed to be innocent. In this matter, the applicant is to prove exceptional circumstances. Let us first deal with the strength of the state case. As was already alluded to, the applicant is to prove exceptional circumstances why he should be released on bail. Where an accused person adduces evidence of innocence, and such evidence is so strong that it can be said that he has reasonable prospects of success at his trial, he has established exceptional circumstances. And this was dealt with in S versus Muhammad, 1999, volume 2, SACR, page 507. In S versus Siwela, a 1999 judgment, it was held that a factor which constitutes exceptional circumstances is the failure of the state to adduce evidence to contradict the accused's denial of guilt. The case for the state is that a cell phone which belonged to the deceased was found to be linked to the applicant days after the deceased was reported missing. The applicant's version was that he had bought this cell phone from a street vendor in Central Park, Bloemfontein, sometime early in December 2023. What appears to be very peculiar and only came to light during cross-examination of the investigating officer was that the seller of the phone had been subsequently arrested and that this seller person acknowledges that he had sold a phone to the applicant. The seller, who actually has a closer link to the phone, is strangely not an accused in this matter. The applicant vehemently denied his involvement in the kidnapping and murder of the deceased. The trial court will ultimately hear all evidence and make an assessment regarding the reliability and the credibility of state witnesses. The trial court will also make an assessment regarding the version of the applicant. It is, however, submitted that the state will find it difficult to adduce evidence to contradict the applicant's version because there is no direct evidence linking the applicant to the offence. Also note, Your Worship, that the phone was not found in the physical possession of the applicant. The applicant willingly, albeit a day later, or day or two later, took the police to his wife, who was in possession of the said phone. The investigating officer furthermore...
Mr. Priest, is it not the girlfriend in Zastron that was in possession of the phone?
Your Worship, there appears to have been some exchange of phones there. But I
Yes.
understand the evidence was either that the phone was found with the girlfriend or the wife. I understood it that it was found with the wife.
Yeah, I understood it that it was with the girlfriend in Zastron. He
As-
bought the phone, then he went to the girlfriend in Zastron. She liked the phone, and they then exchanged phones. The phone that he then gave to his wife was the one that was
As a
received from the girlfriend.
Your Worship, be it as it may, whether it was found now on the girlfriend or on the wife, the fact of the matter is that the applicant took the police to this person who was in possession of the phone. The police would not have even known where the phone was had my client, the applicant, not taken them to either the wife or the girlfriend in question. The investigating officer also testified regarding an unidentified witness who saw the applicant in the vicinity of the deceased. It is submitted that this evidence is so vague that it cannot be reliable. No weight whatsoever can be placed on this assertion made by the investigating officer. It is therefore submitted that there is no direct evidence linking the applicant to the offence, and that this factor should be regarded as an exceptional circumstance. If I may now deal with the personal circumstances of the applicant. In S versus Rudolph, the court concluded that ordinary circumstances present to an exceptional degree may lead to a finding that release on bail is justified. The applicant herein testified regarding his personal circumstances, and his personal circumstances were not disputed by the state. He has 2 minor children with his partner. He is employed as a taxi driver and earns approximately 7,500 rand per month. The applicant is also the sole breadwinner of the family. One may argue that the aforementioned personal circumstances are ordinary, but what makes them present to an exceptional degree is that one of his children suffers from a physical disability that necessitates regular visits to hospital for tests and treatment to be administered. The applicant testified that some visits are necessitated by emergency medical occurrences. The applicant also testified that he is in dire need of his employment, not only to financially maintain his family, but also to ensure that his child has transport to the hospital when such is required. The applicant testified that his employer assists his family in a medical emergency and that his assistance is very importantly linked to the applicant actually working and bringing income to the employer. If the applicant is to remain in custody pending the finalization of the trial, he will no longer be able to provide to his family, which will result in severe financial hardship to his family. The hardship that his sick child will suffer is irreversible and inhumane. It is therefore submitted that this is an exceptional factor to be considered by the court. It is thus submitted that the applicant has proved on a balance of probabilities that exceptional circumstances exist as is required in section 60 subsection 1A, pardon your worship, 11A of the Criminal Procedure Act. If we can deal now with the interest of justice, the applicant is also to show that on a balance of probabilities that the interest of justice permits his release on bail. The interest of justice do not permit the release from detention where one or more of the following grounds are established that is mentioned in section 4 of the Criminal Procedure Act. Firstly, the likelihood that the accused will endanger the safety of the public, any person, or commit a Schedule 1 offence. B, the likelihood that the accused will attempt to evade his trial. C, the likelihood that the accused will attempt to influence or intimidate witnesses or conceal or destroy evidence. D, likelihood that the accused will undermine or jeopardize the objectives or the proper functioning of the criminal justice and bail system. And E, in exceptional circumstances, there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. In this matter, the applicant voluntarily testified regarding the two pending cases which he is facing in Vicksburg and Sterkfontein. He firstly faces a charge of assault, but it was his undisputed evidence that the complainant in the assault matter is a male person. The second pending matter is a charge of theft of a motor vehicle. It is submitted by the applicant that theft has no element of violence. The applicant rightly responded in cross-examination by the state that although he acknowledges that he has two pending matters, he has not been convicted in any of these matters yet. The applicant also gave an explanation as to why a warrant was issued for his arrest in the Vicksburg matter. It was his version put to the investigating officer that he was required to attend to his trial in Sterkfontein on the same day on which he was to attend the matter in Vicksburg. It is submitted that a situation such as this is not unlikely and indeed possible. It
Mr.
must...
Priest, but
Yes, Your
that
Worship.
situation, if the accused appears in two different matters, if I look at the evidence correctly, he appears in one court and he's released on bail and he's given a date. Then he's later arrested for another matter. He appears in that matter, he applies for bail, and then they postpone that matter also to the same date. Why would the accused not in that circumstances inform the court or his attorney, but I've got a pending matter that's appearing on the exact same date?
Your Worship, if I may address the court on cases that I've witnessed personally. You many times find an accused person who has to appeal or has to appear, for example, in this court, and we also find him, he's taken to another court to appear. Sometimes it also happens that accused persons don't remember the dates properly. Your Worship will remember that during his testimony, my client did indicate that he tried to inform the investigating officer that he must first appear in his trial matter in Sterkspruit. And according to him then, the investigating officer then told him it would be sorted.
But that was his evidence when he was confronted in cross-examination. But his evidence in chief was that I've got 2 pending matters, and then he gave dates when they were appearing. So in his evidence in chief, he did not inform the court to say, I've missed one of my appearances. He gave specific dates when he is appearing in those matters. I just want to see if I can quickly gather the dates. Have to have a look, but regardless, he did provide the specific dates that he stated that they are appearing.
Yes,
And my question in that regard is, why would he provide those dates if he didn't have those dates? Because the evidence for the state is that he missed his appearance, and therefore there's a warrant in the one matter. But both those dates were dates that are in the future that he gave.
Indeed so, Your Worship. Your Worship will be reminded that he was cross-examined regarding the warrant by my learned friend for the state. It's my submission that he did give a plausible explanation. The investigating officer did indicate when testifying regarding this aspect that the investigating officer in the Vicksburg case did not allude to this when the investigating officer in this particular case discussed the applicant's matter with him. But what remained clear is that my client did give an explanation. It's my submission that it is possible, though it doesn't regularly happen. We've seen it happening in our courts. And also, very interestingly, it wasn't mentioned by the investigating officer that there had been warrants issued for my client prior to December, if I recall correctly. So there wasn't any history other than this specific date where a warrant was issued in the Vicksburg matter. A history of not attending court and not appearing in matters placed before this honourable court. And I will humbly request this honourable court to take that also into consideration.
Thank you. You can proceed.
As the court pleases, Your Worship. It must be noted in favour of the applicant that he has no previous convictions. It is thus submitted by the defence that the state did not make out a case that there is a likelihood that the release of the applicant will undermine or jeopardise the objectives of the proper functioning of the criminal justice system nor the bail system. It is also argued that the state did not make out a case that there is a likelihood that the applicant will endanger the public or a person, nor was a case made out that there is a likelihood that the applicant will commit a Schedule 1 offence. There are no grounds proven by the state that the applicant will evade his trial. The applicant has made out a proper case regarding his roots in Bloemfontein and Sterkspruit. He has a family to support, he has employment to return to, and his family home is situated in Judgement village in Sterkspruit. The state contended that the applicant is a rolling stone, in inverted commas, with no singular fixed address. The applicant, however, could provide an explanation for having 3 addresses. The applicant testified that he was a taxi driver, providing services mainly between Bloemfontein and Sterkspruit. His employment necessitates his sleeping over at various stopovers. The investigating officer testified that his family home is situated in Judgement village, Sterkspruit. Due to his travelling for work purposes, it makes sense that the applicant would indicate that his parental home in Judgement village is suitable for the purposes of bail. It is is also submitted that the applicant could not have provided the court or the police with the address in Bartu location, Bloemfontein, simply because he doesn't have any income longer due to his incarceration. He thus does not have the means to pay rent in this Bartu address any longer, and as a result cannot allege to stay there any longer. The applicant also testified regarding the health issues suffered by his child. The state could not dispute this evidence, and it is submitted that it is very unlikely that the applicant will endanger his vulnerable, sick child by absconding in order to evade his trial. The state furthermore contended that the matter at hand is under public scrutiny and that the community is opposing the release of the applicant. If I may quote Slomovitz, A.J., as was stated in S versus Schittikat, 1991, Volume 1, SACR, on page 100, it was stated, it is true to say that it is the duty of courts of law to ensure that the maintenance of law, order and justice, and so prevent the greatest of all evils, a criminal justice system so weak and vacillating that people feel the need to avoid courts and take the law into their own hands. Despite this, the courts have an obligation to society at large. They must jealously guard the rule of law. A court of law must not permit the body politic to give legislative credibility for whatever reason to uninformed or ignorant public outcry, or to what the government of the day perceives will best assuage those feelings of the general public which, if quelled, are calculated to do no more than to ensure that it be returned to elective office, whether it deserves to be or not. In S versus D and others, it is clear from the provisions of, it was indicated that it is clear from the provisions of section 60, subsection 4E, that only in very exceptional circumstances would a court consider the likelihood of disturbance, public disorder, and undermining of the peace and public peace or security. And in S versus Domini, it was noted that the field of application of section 60, subsection 4E will be extremely limited. If I may add, Your Worship, when this matter commenced a few weeks ago, there were lots of people of the public outside raising placards, objecting to the release of the accused person, the applicant in this matter. And the court will note that today the gallery is not as full as it was on the first day when this matter was involved. Your Worship, to merely disallow my client the opportunity of bail just because there is a community outcry, Your Worship, would be unjust in the circumstances, and that is then also my submission to this Honourable Court. Therefore, there is no evidence before this court that there is the likelihood that the release of the accused person will disturb the public order or undermine the public peace or security. The fact that there is public interest in the outcome of this case has not been shown to be exceptional, and to such an extent that there is a likelihood of public disorder should the applicant be released on bail. In conclusion, Your Worship, it is submitted that the state here is busy with a witch hunt, and that the police is attempting to appease the public by making an arrest, even if the arrest is based on speculation. There is no direct evidence linking the applicant to the crime itself. No DNA at this stage, no fingerprint evidence, Nothing whatsoever, Your Worship. The applicant provided a reasonable explanation that he bought this specific phone from a third party. The police subsequently traced the third party, which only came out during cross-examination of the investigating officer, who confirmed that this person indeed did sell a phone to the applicant. This third party, who in my opinion is a closer link to the said phone, is not a co-accused in this matter. According to my submission, my evaluation of the case, Your Worship, it is my submission that the state did not even leave any evidence to the effect that the applicant committed premeditated murder. It is submitted that the applicant has discharged the onus placed on him by section 60 subsection 11, and that he has shown exceptional circumstances why he should be granted bail in this matter. It is further submitted that the applicant has discharged the onus placed on him by section 60 subsection 4A to E, that it is in the interest of justice that he be released on bail. Your Worship, those are then my arguments before this honourable court, unless Your Worship wishes me to address the court on any other aspects.
Nothing further, thank you.
I thank the court, Your Worship.
Mr. Roti.
Thank you, Your Worship. Your Worship, the state will make the following submission in closing arguments on the bail application that is brought by the applicant. Clearly, Your Worship, section 60 subsection 11A is very clear and straightforward. In that, Your Worship, in matters where an accused person is charged with a crime that is linked to Schedule 6, he bears an onus to show this honourable court that there are exceptional circumstances that warrants in the interest of justice for him to be released on bail. Now, the state will also note the fact that there is an avalanche of case law that deals with what can be described as exceptional circumstances, which the state is not going to bombard the court with because the court is quite aware. However, the state will refer this honourable court to the case of Portem, Porthen, or 2004 decision, Your Worship, volume 2 of SACR, specifically on page 242, Roman figure C, where it was stated that, Your Worship, I quote, in determining whether or not a bail applicant has established the existence of extraordinary circumstances within the meaning of section 60 subsection 11 of the Criminal Procedure Act, the court has to make a decision on the facts judged within the context of a particular case. Facts which might be sufficient in one case might not be enough to warrant the granting of bail application in another. Now, that, Your Worship, the state will align to the personal circumstances that have been placed before this honourable court in the applicant's application in support of his bail application. Let's look at the provisions of section 60 subsection 4A to E. The state will submit that the provisions of section 60 subsection 4A to E are present in this matter on the following aspects. The applicant before this honourable court, when he testified with regard to where does he reside, he spoke about Josanna's Hook, vehemently stating that he stays in Josanna's Hook. And in the docket and also in the charge sheet, the address that is articulated there, it's one at Macheteng village in Sterkspruit, of which the investigating officer has testified to the effect that that address was provided by the applicant as the address where he resides. Now, under cross-examination, it also emerged that the applicant before court is also renting a place here in Batu location, which only emerged under cross-examination. Hence, the state, as my colleague earlier on quoted the state as putting to the applicant before court that he is indeed a rolling stone. In the light of the fact that he cannot articulately tell this honorable court where he resides. The investigating officer testified to the effect that the Johannesburg address is where the accused or applicant's mother resides. It's not where the applicant resides. That is the first aspect. And the second aspect, which also falls within the provisions of Section 60, subsection 4A2E, is the issue of the fact that the applicant before court has got two pending matters. And one of those matters that which the applicant is supposed to appear has got a warrant of arrest being circulated against him. Now, let's deal with the issue of these pending matters which he has alluded to before this honorable court. The state would like to bring the court's attention to the fact that it is the duty of the applicant, when he is an accused person, having two matters that he must appear on, to ensure that if the matters are appearing on the same date and the other one he could not attend to, it is his duty and responsibility to ensure that he actively goes to the court where he was supposed to appear and inform the court that I was in Sterspate court on this particular day, hence I could not appear. He did not do that. Hence, a warrant of arrest and also his bail money has been finally forfeited to the state. Clearly it shows that the applicant before court does have a tendency of undermining the administration of justice in the sense that he was duly warned to appear in Fixbank, and he failed to appear in Fixbank. And he did not make any means to go and inform the court about the predicament of two dates which he was supposed to appear. That on its own, Your Worship, just shows that the applicant before court has a tendency of undermining the rule of law, in the sense that the evidence that is before court clearly shows that he has failed to do that, to honor the court's ruling or directive for him to appear in court. When it comes to the personal circumstances of the accused person, Your Worship, the state will submit that the personal circumstances of the accused cannot be said they are exceptional. Why the state is saying that is because, Your Worship, there's no evidence that has been brought or put before this honorable court with regard in support of the averments that are made by the applicant that he has a sickly child and therefore who constantly require medical attention. The state's submission is that if that is the case, the applicant before court would have, through the usage and also the assistance of his legal representative, provided such information, evidence that supports the fact that he says. So we are now dealing with what he only told the court. There's nothing that supports his averment in that aspect. And furthermore, Your Worship, the state would submit that the applicant before court, his version in terms of how he is linked to this case, Your Worship, is very questionable. In that, when he was arrested, he failed to inform the police about this cell phone that is actually of the deceased. Only days after, volunteered this information. That on its own, Your Worship, just shows that he has not been a willing suspect, if I may put it that way, who would play open cards with the state to say, look, here's the situation, and this is how I got into contact or into possession of this cell phone. Only days after that he led to the police officers to where the cell phone was. And that on its own, Your Worship, just shows that the applicant before court cannot be a trusted or someone that can be relied upon on the basis that 2-3 days lapsed before he could provide the investigating officer and point to the direction as to where the cell phone of the deceased is and where it was recovered. Now, the state, Your Worship, would submit that The provisions of section 60, subsection 8, capital A, are at play in this matter, Your Worship. Capital A and Roman figure A, where, Your Worship, it is stated in the Act that in considering whether the ground in subsection 4E has been established, the court may, where applicable, take into account the following factors. More so specifically, Roman figure A, whether the nature of the offense or the circumstances under which the offense was committed is likely to induce a sense of shock or outrage in the community, or where the offense was committed. That, Your Worship, on its own, in this matter, the sense of shock and the sense of outrage is apparent, Your Worship, in that the community out there and also the society, the media, this matter, Your Worship, has attracted a lot of attention from the society. The society is aggrieved by such instances of violence where children are being kidnapped and killed. And, Your Worship, the state further will submit that the society, as it has been also quoted by my learned colleague, that has so much confidence and trust in these in the courts of law and also in the administration of justice to mete out the required judgments in cases of this nature and the seriousness of this nature, Your Worship, and also the possible sentence of which should the applicant be found guilty of. Is a very lengthy sentence. And that, Your Worship, should the applicant be granted bail in this matter, there is that likelihood that the applicant, in this case, Your Worship, will evade his trial. And based on the aforesaid, Your Worship, the state will submit that the applicant has failed to discharge that onus. And the applicant, I would submit, is only parroting the provisions of section 60, subsection 4A to E. His personal circumstances can never be said they are exceptional and therefore does not warrant him to be released on bail. And therefore the state, Your Worship, will submit that his application to be released on bail be denied, Your Worship. And that is the state's address, Your Worship, unless the court would like me to address it on any other aspect with regard to the applicant's application, that will be the state's submissions, Your Worship.
Nothing further, thank you.
Thank you.
Any reply, Mr. Fries?
I will abide by my arguments as the court pleases, Your Worship.
Thank you. The court is going to reserve the judgment until tomorrow. I do not know if you are available, Mr. Fries. Alternatively, your colleague can maybe just stand in for you for the judgment.
Your Worship, I may not be available, but if I'm not available, I'm sure she will just sit in for the judgment, Your Worship. So it's therefore, I have no objection to the matter being rolled over until tomorrow. So the court pleases, Your Worship.
Uma ngiyothitemhlekazi akazokwazi ukuthatha isigqibo ngawe namhlanje ngokuthi ngaba uyakhulula okanye akakhululi nanke ebheni usafuna ukuyithunga kakuhle le ndaba ngoku ngomso uzawuphinda kwakhona uziswe enkundleni yamatyala zintsha zomthetho uzawuhlala sevalelweni.
So your matter is hereby postponed until tomorrow, the 30th of January 2024. For the judgment in the bail application, you are remanded in custody until then.
The court pleases, Your Worship.
Your Worship, I do believe that this is my role for the day. May I be excused?
Thank you, Mr. Fries. You may be excused, and thank you for the heads of argument.
As the court pleases, Your Worship.